Put myself in here. Yes, good morning, there I am. How do you like that? Good morning, good afternoon. I was going to do one without me, which would be the first time, which would be interesting, but I didn't. Not legal advice. Please like, subscribe, share, show your pets, and that's it. Don't rely upon anything that's said here. Hopefully, it stimulates some thought, and happy to receive any comments, and we'll address them. So today I'm going to address the GTII. I'm going to address the two legal matters that recently have been ongoing. I'll address those briefly. And I'm also going to suggest that as of now, Monday morning, probably around 6:30 a.m., I'll be releasing a video that I think will contain some essential information pertinent to GTI regarding shareholders. So look for that. If it changes, if the timing changes or something intervenes in the meantime, I will let you know that too. But as of now, Monday morning, look for what I think will be a very interesting video that contains very pertinent information that has nothing to do with what I'm going to do today. So that's one aspect, legal aspect or other aspect of GTI. And today we're going to talk about another aspect. But of course, before I start discussing that other aspect, I wanted to briefly address a couple of issues. What is the one type of negotiation that mediators refuse to handle? The negotiation of their own fee, of course. What's the difference between a cowboy and a mediator? A cowboy deals with less BS. And last and not least, it's a repeat of a yesterday joke, but I liked it so much I wanted to repeat it. Bono and the Edge walk into the bar. The bartender turns to them and says, "You two again?" Anyway, so again, important video regarding GTI coming out. Look for it at 6:30 a.m. approximately on Monday. For today's purposes and the discussion, I'll be just addressing the two ongoing cases regarding GTII. And some people were interested in this because Alpine's at the heart of this. People believed, correctly or wrongly, that if Alpine were expelled, which is the process that is occurring, that would trigger some kind of short squeeze. There's issues regarding that because maybe the owners are still operating, moving things around, using profits to pay gargantuan legal fees. That's been addressed and referenced too. So I don't know if necessarily it will be an automatic, but it certainly depletes the assets of these S bags, as I like to call them. And you're aware of the fact there is a proceeding in DC on appeal that was already argued. Uh, that recently, as of yesterday, the court asked that both parties provide an additional brief. So this is the proceeding in DC. That particular proceeding that is on appeal is the denial by the federal court of the injunction that Alpine sought. There was a hearing before the Court of Appeal, and that's the hearing that is under review. And the court asked for additional briefs by both parties. And the basic issue is there's a statute that is available that permits the SEC or the commissioner of the SEC to exclude a broker from being a member of a SRO. And that was apparently a congressional requirement in 1983 or 1984. And the question by the court that both sides are asked to brief is whether that has ever been used and does it apply. So both those issues, and we'll see what the point is. And I guess the question makes me think, and I'm just guessing, but makes me think whether the court is examining whether, if in fact someone's expelled, do they have any other alternatives in the industry? And this is especially sensitive because it was an expedited after 44 years, but expedited expulsion under the process. So I think that's what they're looking for, but I don't know. And I don't know if they'll determine if it's relevant, but that's what they asked. The briefing will be done by March 29th. And after that, I would expect a ruling. It'll be interesting. There's no further oral argument ordered. I guess that could change, but I wouldn't expect that. But that occurred as of March 8th. That request for both parties to submit briefs. I think the first one submitted on March 22nd, the second one on March 29th. And again, the issue is whether the SEC has ever, because there is a statute that permits it, has ever permitted someone not a member of an SRO to continue, and two, whether that applies in the current case. That's the question. So I'll keep you apprised after I see the briefs, and we'll follow that. Ultimately, again, Alpine, to the extent it's pertinent, is walking a death plank anyway. Just a matter of time. They're spending money. Seems like they're spending John Hurry's money, perhaps. I don't know. So let's spend more of it. The other action is, so that was FINRA. That was Alpine and FINRA. The other action's in Utah, also in federal court in Utah, and it's against the NSCC and DTCC. And Alpine, in a series of issues that arose, Alpine was asked to increase their capital requirements based upon risk. So they had to have additional cash available just in case. And that was $10 million. And they were ordered to do that. And they were given notice of the rule change. They objected. They acknowledged they knew that if the rule was passed, they would have a $10 million requirement. Well, anyway, the time comes, they don't have it. And then they misrepresent the fact that they have it. And we go forward. And it turned out that, and they were the only ones. So apparently, this capital issue was raised to 150 different firms. And Alpine apparently was the only one out of the 150 that had a problem with this additional capital, which certainly raises concerns. If they don't have the capital, aren't they a risk, which is the purpose of the capital? We know that apparently that there's different companies involved with Alpine that are either shifting money around or doing odd things. I'm shocked the feds haven't further investigated. In fact, I'm very disappointed the feds haven't, because it's not like this information is secretive. I know that I believe Mr. Hurry, the basically the owner of the operation, is open about the fact that he generates enough money from his businesses, notwithstanding what I say about the legitimacy of them, my opinion, but he makes enough money with them to pay all the legal fees, and he has exorbitant legal fees, as we know. And so it's not really Alpine that's doing it, it's for the Alpine entities. And I think the problem would be for Mr. Hurry or people related to them or other management or other owners, is if the Ferris wheel stops and people get a chance to look at what's going on, I think that's the end for everybody. And that might be, looking at a prison shower at that point in time. So that's why these ongoing legal matters continue to be funded, because it makes no sense otherwise, because Alpine certainly is not generating enough capital to pay the legal fees. As a matter of fact, that should be another issue addressed by the feds, is why would Alpine be paying these legal fees when they can't generate sufficient capital to justify it? What's the sense in that? Aren't they trying to conceal information? That would be the thought process. But anyway, just my speculation. And so in Utah, Alpine went in for the injunction, and yesterday the order was issued by the court. So it happened that both Alpine rulings came out on the same day, which is interesting. And the order of the Utah court, so Alpine went in, they tried to block NSCC from conducting a disciplinary proceeding, an expulsion proceeding, we've heard this before, against Alpine, which is now scheduled for March 18th, 2024. So it's coming up. And they use the same arguments they did in the Washington D.C. circuit, namely there was constitutional violations of the Appointments Clause, non-delegation doctrine, etc. The court denied the injunction yesterday and basically said that these entities, just like FINRA, were not state actors. Therefore, the Constitution didn't apply due process obligations of the Fifth Amendment, the Appointments Clause, etc. And to the extent there's a non-delegation doctrine, that the SROs are closely enough monitored by the Congress and the SEC that that's protection enough, and therefore the injunction wouldn't apply, and there was no likelihood of success on the merits. As soon as that ruling came out, Alpine, again, makes no sense that they're spending money this way, and where's the money coming from, filed an appeal. So that appeal is pending. Now, there's no stay in that matter, so the hearing, as of now, the disciplinary hearing set for March 18th in Utah, based on that Utah case, will go forward. I would expect in the interim that Alpine will probably try to get a stay. So they'll ask either the district court in Utah first, or like they did in DC, they might have asked the appellate court to issue a stay so that the disciplinary proceeding should not go forward. Now, it's a different circuit, so we don't know how it's going to rule, but I'm hoping, consistent with the lower court ruling, that they don't issue a stay and that they move forward with the disciplinary proceeding. Because again, we're talking about risk to the public, because if in fact Alpine does not have sufficient capital to serve as a backstop and is a risk because it provides other parties to the transaction and their risks to the transaction, if that's the case, then they need to be immediately shut down. And as I've called for in the Washington, D.C. matter, that's the FINRA matter, not the NSCC, DTCC matter in Utah, but I've asked and suggested that the feds go in and shut down Alpine. And I'm doing the same in Utah. Again, if there's a risk and the DTCC and NSCC have already indicated there is a risk by requiring the $10 million as a backstop, then they should be shut down, and they should be shut down immediately. And I believe, obviously it would create a problem for all those that are controlled or involved with Alpine. So that's the current story. An appeal was filed. I'll keep you apprised of the appeal. I'll keep you apprised if they seek a stay. But that has nothing to do, just kind of we go back full circle. This, although if in fact Alpine's excluded and maybe other entities down the road are also, that would be beneficial, I think, for everybody. And would it cause a short squeeze? That I have no idea. Would it help the stock price? I have no idea. But it would certainly get rid of bad actors, in my opinion. So if that happens, that would be great. And it has not happened as of now, so they haven't been shut down as far as I could see. But what I'm going to talk about on Monday has nothing to do with this. So it relates to another aspect of GTII and is not influenced by this stuff. So even if this stuff doesn't result in a dramatic change in the status of GTII, perhaps what I'm going to talk about on Monday might. We shall see. And again, if that changes, I will let you know. Otherwise, I hope this provided clarity as to what's going on in the GTII. Again, quick summary: Washington case, which is on appeal before the DC Circuit. Court ordered additional briefs, one March 22nd, one March 29th, related to whether the SEC has ever ordered a brokerage to be permitted to operate without being a member of an SRO, and if that statute applies. And then we have the Utah matter, where that's the NSCC and the DTCC versus Alpine, related to capital requirements, not their other scumbaggery. And that hearing occurred, injunction was denied, appeal filed, disciplinary hearing set for March 18th. Keep you apprised about all that, and I'll probably see you on Monday morning early unless that changes. And if it changes, you'll see me earlier. Anyway, be well, have a great day, and take care.